Hello to everybody. My name's Neil, obviously. I'm serving as moderator for today on behalf of the Law Society of Yukon. It's just so everyone's aware, this session will be recorded for future use. It is being recorded as we speak. As for CPD credit, this counts for 1.5 hours. We're scheduled until 1 o'clock. Today, we will be going over Introduction to Condo Corporate Governance with Leslie McRae. Leslie has lived in the Yukon for more than 40 years. She was called to the bar in Yukon and BC in the year 2000. Since then, she has practiced residential and commercial real estate and has had a long career at Northwestel, serving as their general counsel, corporate secretary, and chief privacy officer. Leslie was appointed Registrar of Land Titles in January of 2021. Now, as I understand it, she is open to questions as we proceed. So given we're on Zoom, you can test out the raise hand function or type something in the chat and I will let her know. I believe we'll also have time for questions at the end. But without further ado, I will pass it off to Leslie.
Thank you, Neil. So I acknowledge with respect that this event takes place on the traditional territory of the Tanquichan people and the Kwanlin Dun. So the presentation is going to provide you with basic information about the new Condominium Act and regulations that came into effect on October 1. Most of the requirements in the Act and regulations apply to condominiums regardless of when they were created. There are some special provisions and transition periods for pre-existing condominiums that are specifically stated in the Act. And Section 239 is the transition provisions. So this is intended as a general resource. This is not legal advice. This is not a legal opinion. And it doesn't deal with many of the matters that might be of interest to condominium corporations or lawyers giving advice to condominium corporations. It doesn't deal with how to make fundamental changes to the declaration and bylaws. It doesn't deal a lot with financial management or some other things as well. And also, I wanted to make a quite important disclaimer for myself. Most of the subject matter of this presentation is way outside the responsibilities of the Registrar of Land Titles and the Land Titles Office. I can't emphasize enough that condominiums are self-governing. There's no enforcement of the Act by Government of Yukon. The Registrar of Land Titles is responsible only for the provisions of the Act that deal specifically with registration or filing at the Land Titles Office, such as creation of a condominium itself, the annual filing requirements with land titles, prescribing forms where the registrar is authorized to do so or required to do so. So please, in the future, do not ask the land title staff to interpret legislation for you unless your question is related specifically to registration or filing in the land titles office. Thank you. I'm sure you can imagine that I'm saying that because I have to, given the number of inquiries that we've received in the past year. So I hope to cover, and this is a very long presentation, it's 40 pages long. I really wanted to go, sort of against PowerPoint presentation best practices because I thought this would be helpful, perhaps in the future, as a quick resource. If you don't know what section of the Act to go to, or if you're not familiar with the Act. So I've included more detail than is typical in a PowerPoint, and I've included, I hope everywhere, all of the section references to the Act or regulations. So I hope we'll cover a broad variety from governance, the board of directors, financial statements, meetings, resolutions, bylaws, the transition periods, enforcement of rights, disputes, reserve funds and reserve fund studies, insurance, some information about records that have to be maintained, information certificates and other certificates, and then finally land titles filing requirements. So under the former legislation, under the old act, as those of you who practice in the area know, many matters are regulated through the declaration and bylaws. The new act changes that. Most governance is set out now in the act, including repair and maintenance obligations, all the annual meeting requirements and information about resolutions in lieu of meetings, how voting rights are exercised. There's specific requirements about budgets, financial statements, reserve fund studies and reserve funds, insurance coverage, annual filing requirements and records. Condominiums created or designated as pre-existing condominiums before October 1, 2022 are governed by many transitional rules. And as I mentioned, the transitional rules are set out in 239 of the Act. I've given a list of examples there of some of those transitional rules. I'm going to make a note about my fourth bullet point that says certain sections of the Act, Section 9 and Sections 55 and 56, do not apply to pre-existing condominiums. Section 55 and 56 deals with the contract of purchase and sale between a developer and a purchaser. So keep that in mind if you have any questions about that. I wouldn't normally touch on it in this presentation, but it's important for speaking to realtors lately. This is a not well understood provision of the Act, is when it applies and when it doesn't apply. So there's certain sections of the Act that deal with reserve funds and reserve fund studies that don't apply until certain time periods have passed. The same with the budgets and insurance coverages until certain time periods have passed or certain events occur. And you'll see I've given you the section references there. So the first topic of governance is the board of directors, determined by the bylaws. There's rules about how many owners, if there's more than one owner of a unit, how many may be on the board. If the owner is a corporate, body corporate, there's rules about that. And primarily the Act and regulations determine the duties of the board, but bylaws can also, there can also be bylaws that determine certain matters, how often the board might meet and what its functions and responsibilities are. Some functions and responsibilities can be kept in the hands of the unit owners rather than the board. People who are eligible, not surprising this in a corporate context, not surprising that certain individuals are disqualified from being directors. Unit owners with a lien registered against their unit are not qualified to be directors or not eligible to be directors. The rest really is not a surprise. A director may be removed by an ordinary resolution of the unit owners. The corporation does, however, have the option to change eligibility rules by passing a bylaw at a general meeting. Not surprising as well in the corporate context, directors are required to act honestly, in good faith, and in the best interest of the condominium corporation. You can see how easily, since the directors are also unit owners, that can lead to conflicts of interest. So there's provisions in the Act about how conflicts, what conflicts and how they are to be declared. There's also a requirement for the condominium corporation to maintain directors and officers liability insurance and indemnification. I think I don't think the provision about payment. Directors may be paid for acting as directors, either, and that has to be approved in advance in a bylaw, or it can be approved approved in advance in the approved budget, which is approved each year at the annual general meeting, or by a special resolution outside a regular meeting. Financial statements and budgets are dealt with in Part 7 of the Act. There's a requirement for annual financial statements to a particular standard. The responsibility of the board of what type of financial documents have to be prepared and presented by the board to unit owners depends on where the condo corp is in its creation and development. So there's different requirements for in the transition period after it's built, but while the condo corp is still in the control of the developer, or if it's in the transition period, after that, or if it's after the second annual meeting. The standard that the condo corp has to have its financial statements prepared to is for condos with under 75 units, not-for-profit organizations, unaudited, over 75 units, sorry, not-for-profit organizations, and audited. However, unit owners can waive the requirement to have audited financial statements. That would have to be done yearly. Annual meetings, this is, I'm sure, all familiar to everyone who practices in this area. Like every other body, corporate, or society, annual meetings are required at which certain things must be done. The board must present financial statements, an annual budget, and a report on insurance as well. The voters, the unit owners can waive the requirement to hold an AGM if they consent in advance and also take care of those things, approve the financial statements, budget, and appoint a board of directors. There's other meetings that the condo corp and the board can have. For example, if the board fails to call meetings when they're required to be held, unit owners have the right to convene a meeting. There's different rules depending on what type of meeting the unit owners want to call. And there is a threshold if it's to consider a special resolution. Voting rights now under the new legislation are established in the declaration at the time the condo is created. There is a schedule of voting rights. There is little to no guidance in the Act about how voting rights are established. There's nothing in the Act that prohibits larger units than having more than one vote, for example. Commercial units over residential units having different voting rights. There's provisions in the Act that allow a unit owner to assign their voting rights. There's specific provisions to assign voting rights to a tenant in possession or to a mortgagee. As well, there's proxy provisions for a unit owner to appoint someone who is not a tenant or a mortgagee as a proxy. Resolutions in lieu of meetings, also a very common corporate law concept. The Act says specifically, and I've given examples here of the types of decisions that may be made by ordinary resolution of the unit owners. And the Act also establishes the threshold 50%, more than 50% of the votes cast. Special resolutions, again, the Act establishes which matters require a special resolution and what the threshold or percentage of eligible voters is to approve the resolution. And the bylaws can set a higher percentage of voters required to do certain things, to amend the declaration, for example. So here's a long list of all the things that a special resolution, I'm not going to say all the things, most of the things that a special resolution is required for. I'm not going to go through these in detail. If there's anything that surprises you, you want to ask a question about, just put up your hand or put a question in the chat. But I don't think there's anything particularly surprising here. Some of them are specific to condominiums, of course, such as assessing special levies. That is a question that seems to come up. In addition, this is one of the transitional provisions of the Act. For condominium corporations that were more than 10 years old when the Act came into force, If they want to waive the requirement to obtain a reserve fund study, they have to pass a special resolution to do that before October 1st, 2027. That resolution timeframe is only 1 year, and they would have to pass a special resolution each year before the expiry of the previous 1 year period. So year after year after year, a condo corp that was more than 10 years old on October 1, 2022, can waive the requirement for a reserve fund study and a reserve fund. Unanimous resolutions, not surprisingly, but you know, the most important decisions, the three that I've given examples of, are a decision not to use insurance proceeds to repair or replace damaged property, to change the designation of exclusive use common property or common assets, or to terminate the condominium corporation. Resolutions may be passed in lieu of a meeting as long as they're passed by the necessary percentage of eligible voters. So an ordinary resolution by more than 50% of eligible voters, a special resolution by 70% of eligible voters, unless that percentage has been changed in the bylaws. And I'm sure this will surprise you, a unanimous resolution by 100% of the eligible voters. So should I just stop here for a minute, Neil, and see if there's any questions or anyone's got their hand up before I move on to bylaws?
Sure, I've been checking checking the chat. There's no questions, there's no hands.
Okay, great, thank you.
Yep.
So moving on to bylaws, the Act says, sets out the requirements for bylaws in 3 ways. The condominium corporation must have bylaws about this, that, and the other. It may have bylaws about this, that, or the other, and it must not have bylaws about this, that, or the other. So those are all set out specifically and listed in the Act. So these are the 4 items that a condominium corporation must have bylaws about: the control of managements of units, common property, and common assets, the board and administration, insurance, and the interest rate that the corporation may charge on unpaid assessments or fines. That last one is weird, but that's what it says. Here's the may. This is a not exclusive list. So, because you'll see that it says other matters that the Act permits to be determined in bylaws. Oh, I just got a pop-up that there's a question.
Yes. So what the question is was more of a comment, apparently, that this is great, but the information's a bit too fast, so.
Oh, sorry. Okay. I will slow down. I'm trying to keep my eye on the time at the same time as I'm keeping my eye at the page numbers. So thank you for that feedback. So the may part simply means that if we go back to the previous screen, that these are the 4 items that a condominiums corporation's bylaws have to deal with. The Act doesn't say what the bylaw has to say. It just says you have to have a bylaw on these topics, on these matters. Then the bylaws may also deal with all of these other things. I'm just going to take a minute to talk about sections within mixed use developments. The Act and regulations refer to mixed use as being potentially a mix between commercial and residential units. I suppose I should say units for a commercial purpose and units for a residential purpose, but you know what I mean. Or it could be a mix of conventional units and bare land units. And when you think about the different interests, it would be difficult to write one bylaw. It would be very long. So what the Act allows is what are called sections. You can have a residential section with its own bylaw that only deals with the matters that the residential unit owners want to deal with. And you can have a commercial section that has its own bylaw that only the people who own commercial units want to deal with. And then likely there would be a one bylaw that would be for general administrative matters as well. So the other things that a bylaw may deal with is attendance at general meetings. That just means who may attend. Is it only the board of directors and the unit owners? What about the auditor, if there is one, accountants? What about spouses or family members of unit owners? Can they attend an annual meeting? It's important to understand when it talks about who can be a director of a condominium corporation and instead a unit owner is who's registered on the title. So if you have a person registered on the title, that person's spouse is not a unit owner. So that person's spouse is not entitled to be a director. And depending on what the bylaws say, may not be entitled to attend a general meeting. Your bylaws can also deal with fines and in what amount and for what offenses fines will be assessed. Expenses not included in the annual budget. The Act contains specific provisions that say what the annual budget is required to contain, but there may always be circumstances where an unexpected expense that has not been approved by the unit owners comes up in the middle of the fiscal year. So your bylaw can contain provisions about how that type of expense is dealt with, whether it's you can set out rules for the type of expense or the amount of the expense, and potentially give the board of directors authority to pay the expense without having to go back to the unit owners and amend the annual budget. So that's quite important, I think. And then I said non-exclusive simply because there are other matters that the Act permits to be determined in bylaws. I haven't attempted to list what those other matters might be or what sections of the Act or regulations refer to if provided for in the bylaws or subject to the bylaws. So there's a requirement now that the bylaws be filed in the Land Titles Office. Filing has a specific meaning under the Condominium Act, and it is not registration. Bylaws will no longer be registered as an instrument against a certificate of title. They will be filed or recorded in the condominium's records folder. And an amendment to a bylaw or an amendment to a bylaw does not take effect until that filing has been completed with Land Titles. And I can tell you Land Titles is thrilled about this. Absolutely thrilled. The condo corp must inform unit owners and residents of any change to the bylaws as soon as feasible. So, there's a regime in the Act about how bylaws can be amended, but, potentially the board might have the authority to amend a bylaw and it might remain in effect until the next annual meeting of the unit owners. But generally speaking, this is because participation at annual meetings may not be high, and people who live in the units may not be the owners, they may be tenants. So the board is responsible to make sure all unit owners and any residents who are not unit owners, so any tenants, are informed of changes to the bylaws as soon as feasible, as soon as practical. And here's the restrictions. The bylaws must not. You can't have bylaws that conflict with the legislation. You can't attempt to do something in the bylaws which the condominium plat, or the declaration and plan have already established. Still existing and somewhat controversial, particularly with the cost of insurance. Bylaws may not restrict an owner's right to sell, lease, or mortgage their unit, but may regulate use through rental restrictions. It says bylaws may not restrict. I have not dealt with whether your declaration can restrict an owner's right to freely sell, lease, or mortgage a unit. So the Act creates the concept, which is familiar to many of us, of implied easements. These are easements for structure and support, particularly of the type of condominium that is like row housing, for example. Those implied easements exist by operation of law, by operation of the Condominium Act, and the bylaws cannot change them. The bylaws cannot deal with common property or common assets. The bylaws cannot restrict use by the unit owner's family, but may limit the number of people and pets living in a unit as well as the age of occupants. So that's a provision that you can include in your bylaws with some limitations. And as I mentioned before, the bylaw may restrict activities related to the sale or rental of units. Oh, I see we have a raised hand.
Oh, yep.
It's actually popping up on my screen, Neil. It didn't do that the last time we were doing this, so I couldn't tell when anyone was asking. Oh, and so
Oh.
does Leslie McRae. I can't see
I'm
the
not sure.
question, but I only see that they raised their
No,
hands.
and I'm not sure if they can
Hang on just a
actually
second.
use them.
Let me see if I can get them. No, I can, I can open the chat and I can open the Q&A, but I don't know what to do about raised hands.
Yeah, I'm not sure if they can actually speak in the format we have. So if you can type your questions.
Yeah, if you wouldn't mind typing your questions in chat, then I can actually see them because I figured out how to do that. And I'll give you a couple of seconds to do that. Let me just check what our next section is here in the presentation. Oh, I'll just deal with transition periods while we're waiting for people to put their questions in the chat. So the transition section of the Act, Section 239, I find that Section 239 requires extremely careful reading. It's very layered, and it refers off to other sections. It's very challenging, that particular one, to keep in my mind. I have to go back and look at it every time I think about it. So first of all, the bylaws, the governing documents of the condominium corporation are deemed to comply with the current legislation if they complied with the former legislation. Except that, of course, there are things in the new act that do overrule the bylaws. Bylaws continue to be enforced until they are amended, replaced, or repealed. If a condominium corporation is going to amend its bylaws, it has to update all of its bylaws. Because generally speaking, you can't have a situation where you expect your board and unit owners to be referring to old and new, which may deal with the same subject matter. That was just seen as something that was practical. So let me see if I can get into the.
Nobody's typed anything, so I would encourage if you have a question, it seems like we can't get you on audio. If you can type it into the Q&A at the bottom, then we will see, and Leslie can answer your questions.
Yeah, I can see it when I get a little blurb on screen that tells me that someone has done something. And hopefully we'll have plenty of time at the end for questions as well. And then maybe by then I will have figured out how to unmute everyone, which would be good at the end. So in addition to bylaws, the Condo Corp may make rules. The rules are really housekeeping. For example, making rules about when the common laundry facilities or when the pool or exercise room can be used. All of the same restrictions, the must-nots, that are set out in section 106 relating to bylaws apply equally to rules. You can't use rules to do things that you can't do in the bylaws. And rules that conflict with bylaws are of no force and effect. In addition to the obligation to inform unit owners and residents of any new bylaws, there's the same obligation to inform unit owners and residents of any new rules. It's important that, for folks to understand that rules are made by the board, not by the unit owners. They're made by the board. They come into effect immediately after the board makes them, but they only stay in effect until the next annual meeting. If not ratified by the unit owners at the next annual meeting, the rule expires. So enforcement, again, as I said at the beginning, I really cannot emphasize how important this is for folks to understand. Condominium corporations are self-regulating. The board determines, and in the absence of the board, the unit owners can determine how bylaws will be enforced. The government of Yukon has no authority to enforce condominium bylaws or rules. The board has a variety of enforcement options open to it that includes fines, controlling or prohibiting access to common property. They can act directly. They can step into the shoes of the unit owner to deal with tenants. The options include voluntary dispute resolution, if provided for in the bylaws. This is not a non-binding process. Mediation and arbitration under Yukon law, or application to the court. So I've referred here in this last bullet point, application to the court. I've said the corporation, a unit owner, or an encumbrance holder may apply to Supreme Court. But if I'm recollecting this correctly, I think that might not be correct. I think section 210 of the Act, just might want to make a note to check this for yourself, says an interested party. There are certain things that only the corporation, a unit owner, or an encumbrance could apply to court about, but there is another section, I think it's section 210, that says other interested party to require the condominium corporation, for example, to fulfill its obligations under the Act. And the only thing that came to my mind, and I'm sure there's a dozen other things, but because I'm in the land titles office, I'm always thinking about, real estate. What I was thinking about was that if, for example, a unit owner requested, or a unit owner's mortgagee, or a real estate agent on behalf of a unit owner requested the corporation to provide an information certificate, and the information certificate wasn't provided within the time requirements in the Act, which are either 7 days or 10 days, depending on the type of information certificate. That might be a situation where perhaps a potential purchaser might, it seems like trying to kill a mosquito with a sledgehammer, but might want to apply to the Supreme Court, ordering the board of the Condo Corp to deliver the information certificate. Okay. Reserve funds and reserve fund studies. So prior to the new legislation, condominium corporations were not required by law to obtain a reserve fund study or maintain a reserve fund. Generally speaking, it was a requirement that the condominium owners may have felt was practical. But from what I understand, a reserve fund study or a depreciation report is a pretty common requirement of insurers. Insurers want to know that the condominium corporation has sufficient funds to deal with depreciation, oh, things like repairing the roof, replacing the heating systems and things like that. So in the 2015, in the Condominium Act 2015 and its regulation that deals with reserve funds, there is now a specific requirement to obtain a reserve fund study to estimate the expected life and repair and replacement costs of common property and common assets. Not of individual units for bare land units. Those are not common property. So a qualified person is authorized to, can be authorized to conduct a reserve fund study. There are special rules that deal with whether there are more than 12 units or less than 12 units. For a condominium corporation that has more than 12 units, it has to be the person conducting the reserve fund study must be at arm's length from the developer. And what this tells you that a reserve fund is required to be established when a condominium is created under the new act. So the person approved by the board does not have to be at arm's length if the condominium has not more than 12 units. So this is a slightly challenging area for the larger condominiums who have had reserve funds and reserve fund studies done for many years, perhaps. And now there's legislation and regulations that are putting a framework around what they've been doing for several years at their insurer's request. So it wouldn't surprise me if those of you who give advice to condominium corporations might want to look at this area and understand it. I've had two questions in the last, no, sorry, three questions, including today, in the last week from board members of a condo corp who do not understand how they assess contributions under the new act for special levies for the reserve fund as compared to how they have been doing it under when there was no legislation. And I, of course, cannot give them advice about that. It is not within the responsibilities of the Registrar of Land Titles. So there are timelines. A condominium corporation is required to obtain a reserve fund study within 5 years of the act coming into force and every 5 years after that. That doesn't mean not that you don't have to have a fund. When the condominium is created, the developer has an obligation to pay into the fund. So the fund has to be created then. But the contributions to the fund are approved in the budget as part of the annual budget. The directors are required to determine what the appropriate contribution is and present that to the unit owners as part of the annual budget. And then a share of each unit owner's monthly condo fee is deposited into the reserve fund, which must be maintained as a separate fund. And it must be kept separate from operating funds. It has to be deposited promptly so that it can earn some interest. There are restrictions on what can be spent out of the reserve fund. Expenditures can only take place if it's consistent with the purposes of the fund. I think it's kind of odd or redundant that the act felt it necessary, that the drafters of the act felt it necessary to say that. The fund is created as a restricted fund for a particular purpose. However, I suppose that make it, belt and suspenders approach there. That the expenditure is authorized in advance by a special resolution of eligible voters and enough will remain in the fund after paying the expenditure to continue to pay for major repairs or replacements. So who's exempt and what are the transition periods? So a condominium with 2 or fewer units, duplex style condominiums, for example, are exempt completely from reserve fund study and reserve fund requirements. Completely. They're not required to have a study and they're not required to have a reserve fund, regardless of when they are created. Condominiums that are less than 10 years old on October 1, 2022 are exempt for a period of 5 years. So effective October 1, 2027, they've got to have a reserve fund study done and they've got to start paying into a reserve fund. As I explained earlier, condominiums that were 10 years older on October 1, 2022 are exempt from the study requirements for 5 years and may waive that exemption or not, sorry, not may waive the requirement or may continue the exemption, let's put it that way, by special resolution for periods of 1 year at a time. When you read this section of the act, it's just going to make me bang my head on the desk because it's so convoluted, it's really hard to understand. So a special resolution, a condo corp that was 10 years old or older on October 1, 2022, a special resolution of the unit holders before October 1, 2027, they can extend the exemption for 1 year. Each year, year after year, by passing a special resolution, they can extend the period again for 1 year. The special resolution has to be passed before the last period of exemption ended. Maybe I'm the only one that finds that hard to understand. So insurance. Insurance is the topic that we hear about more than any other at the Land Titles office. People are extremely disappointed when I tell them I can't give them advice about insurance coverage. I can only direct them to the requirements of the Act. Again, there are transitional periods. So generally speaking, a condo corp has to obtain property insurance covering replacement cost of the common property, the common assets, any managed real property. So there are prescribed perils in the regulation. Not surprisingly, lightning, windstorm, precipitation, water escape, explosion and implosion, smoke, strike, vandalism, and malicious acts. In addition to fire, those are the prescribed perils. So the condominium corporation must insure any common property and common assets, any fixtures that were part of the original construction, and condominium units that are not bare land units, but not additions, improvements, or upgrades made to the unit by its owner after the original construction. So that would include additions, improvements, or upgrades made to the units by the condominium corporation. There are, of course, special provisions that deal with bare land units, because those, of course, all the condominium corporation and unit owners, it's just the condominium creates the subdivision of the bare land, not any of the buildings, unless there is managed real property. And managed real property is essentially structures that attach the dwelling or building on one bare land unit to a structure or building on the adjoining bare land unit. Again, think row housing. Shared roofs, siding, exterior doors and windows, if those are identified as managed real property, then they are a common asset of the condominium corporation, and the condominium corporation must maintain insurance on those assets. It's a significant concern to me when I hear people say things to my staff like, oh, well, we're a Bearland unit, so we don't have any condominium corporation. Oh, are you in Whistlebend in a row house? Yes, we are. Well, then you do have a condominium corporation. Oh my gosh. The lack of understanding of folks when they buy a condo, of what they're buying, what their ownership structure is, what the requirements are, is really kind of scary. Really kind of scary, judging from the questions that come in our door. Insurance continued. I could probably we'll probably talk about insurance and the questions we get about insurance, particularly as it relates to duplex style units forever. So unit owners, of course, can obtain additional insurance if they wish to, and they must obtain their own general public liability insurance. There are minimum requirements in the Act for that general public liability insurance. The condominium corporation, I think I mentioned this before, must maintain insurance against liability arising out of any act or omission of a director or officer carrying out their functions and duties. That applies to Bearland condominiums as well as conventional condominiums. That might, for a Bearland condominium, might be the only expense for which people have to pay condo fees. Probably not, depending on the type. There's probably snow clearing and things like that as well. So exemptions, condo corps, the unit owners may annually authorize the condo corp not to maintain insurance against a specified peril if there's either no reasonable risk to property from that peril, or if insurance against the peril is not reasonably available in the Yukon. Now, when you consider that reasonably available, a client may come to you and say, it costs too much to get that type of insurance. And the question you may be asked is, does that mean it's not reasonably available? The other exception that the unit owners can determine is to reduce the amount of insurance coverage or to increase the deductible regarding a particular peril. So it might be extremely expensive to get a particular kind of coverage. But if you reduce the maximum amount the insurance company has to pay out, or increase the deductible that the condominium corporation would have to pay in the event of a claim, it might significantly reduce the cost of the premium. Each year, the board is required to review insurance coverage to determine whether or not it's adequate and make a report and recommendations to the owners at the annual meeting. Transition periods for insurance. So the transition periods are, again, in section 239. So the insurance requirements in the old Act will continue to apply, and the insurance requirements in the new Act will not apply until either April 1, 2024, or the expiry of the condominium corporation's current policy of insurance, whichever is later. So potentially, insurance companies have, what is that, 18 months? Or not insurance companies. Condo corps have 18 months to sort out. They can apply the new Act earlier if they choose to, or if they can have the provisions of the new Act apply earlier if they choose to. But essentially, they have less than 6 months now, I think. April 1, 2024. Yeah. So on April 1, 2024, all condominium corporations, regardless of when they were created, how large they are, or how small they are, have to comply with the requirements in the new legislation. Moving on to the topic of records. I don't think there was anything in the former legislation that dealt with the types of records that a condominium corporation has to prepare and keep. But there certainly is in the new act, and it's a long list. Oh, I see Q&A. Let's check it, see if it's about insurance.
We
And
have
then,
one from an anonymous attendee is asking
excellent.
insurance for a strike by whom? Employees of the city of Whitehorse who are striking and do not provide sewer repair services. No telephone or internet services provided to all condo units are lost due to Northwest Tel striking employees.
Okay,
So I think
well,
those, yeah.
why are you picking on Northwest Cal? Is it because you know I used to work there? Come on now. That's a joke. I can't answer the question. Um, that's a question for an insurance broker or an insurance underwriter, not for the Registrar of Land Titles. I do not know whether you would find the answer to that question in the Act or regulations. Sorry. It's a really good question, though. As far as I recall from the regulation, the word I've used, the language I've used in the presentation is exactly the language that is used in, we're looking at slide 31. Prescribed perils include. That's pretty much exactly what the regulation says in the condominium general regulation. I don't think it describes or provides a definition of strike. So sort of help in a negative way. Alrighty, thank you for the question. Records. Fascinating. I somehow get the feeling that as boards of condo corp changes along with the outgoing board is a banker's box and they hand it to the incoming board. That's certainly the way it works on most of the societies I've been involved with. Um, there's a significant now, significant, I mean, in the terms of you've got to keep everything. The condominium corporation has what they're calling key records, but essentially the key records are specified in the condominium general regulation, and they are not surprisingly all of the documents that were relied on to create the condominium development in the first place, the plan, the declaration, all the building permits and structural and architectural working drawings, the as-built drawings, the budget and financial statements prepared by the first directors, income tax returns, any contracts, surprisingly, the information certificates that the condo corp has had to issue, and any disclosure statements that relate to phase development disclosure statements. So there's quite a list in the regulation. The time periods are also prescribed by the regulation. This is a requirement I think that most people will never have thought of. Imagine that if you're in a business corporation or even in a society, if Revenue Canada has any part of your corporate life, most people think about the records that you're required to keep for Canada Revenue Agency, but The Condominium Act takes a different perspective of it. It's to ensure the owners and people requesting information from a condo corp, that the information is readily available, easily available to those folks, which leads us right into the topic of information certificates. There are three different kinds of information certificates. There is a long form of information certificate, which we've prescribed as a form called Form 37. It's provided for in Section 186. There is a long list. There are, I think, 14, 15, 16 different items that a person can request information and documentation. It is mandatory that the condominium corporation provide the information within 7 days of receiving the request. And the condo corp may charge a fee of up to $50 for the information certificate. So as you see, that includes that is information. The request is made for information about a specific unit, not about the condominium corporation generally, but that request also includes other information that is not specific to the unit, which, for example, management agreements, amounts of any future special levies, copies of key documents for the condo corp. This is seen as a really vital and important consumer protection mechanism to ensure that potential purchasers, tenants, and mortgagees, not tenants. I don't think tenants are entitled to ask for it. Who's entitled to ask is in 186. An owner, a mortgage holder, or a potential purchaser. Those are the three categories, or someone acting on their behalf. The other forms of certificate are, first of all, it's a certificate that someone can ask for relating specifically to insurance. It's a different section of the Act. It's Section 181. It is in a prescribed form. It's Form 38. And it just deals with insurance. And for some reason, the condo corp has 10 days in order to provide that information. But again, the condo corp can charge $50 to provide that certificate. The information, the certificate that I deal with at the Land Titles office is called Form 31. The Condominium Act contains a requirement that the registrar shall only register a lease, assignment of lease, mortgage or financial encumbrance, or a transfer of a unit if it comes along with an information certificate. And it left, this is a requirement under subsection 18.3 of the Act. It left it to the discretion of the registrar in prescribing the form for the information that the registrar felt would be relevant. Quite frankly, the registrar doesn't think any of this information is relevant to registration at the Land Titles office. My understanding from making inquiries is that the certificate comes from a requirement for the certificate is essentially a cut and paste from British Columbia. And what it was intended to do was to protect potential purchasers from unknown special levies to fix leaky condos. And the important thing about it was the condominium corporation, when this is requested for them, and I think in BC it's called a payment certificate. The condominium corporation had the power, had the authority under the Act, the Strata Act in BC, to withhold providing. They could refuse to provide the certificate, and therefore the transaction could not complete at Land Titles if there were unpaid fees or unpaid levies until arrangements were made to pay them. Unfortunately, that part of the BC legislation did not get into the Yukon legislation. The Yukon legislation says that they can withhold the information certificate until they get their $50, not if they need to be paid any special levies. As well, in the Yukon, the risks are very different. I can't help thinking that the drafters of this section may not have completely understood how real estate transactions close in the Yukon, because in BC, when the real estate transaction closes, the purchaser's lawyer gets the mortgage money, gets all the purchaser's cash. Generally speaking, they pay only outstanding property taxes, and they hand the rest of the money over to the vendor's lawyer. And it is the vendor's lawyer who's on undertakings to pay out any other registered encumbrances that need to be discharged, as well as any other liabilities related to the property, which would include condominium fees. That's not what happens in the Yukon. In the Yukon, it is the purchaser's lawyer who does the due diligence for taxes, condo fees, anything else that might be registered against the vendor's name. And it is the purchaser's lawyer who pays out all the funds to all of those folks who might have liens or charges or special levies. So the risks are different between the Yukon and BC, and as is our closing procedure. So if I could wave a magic wand, I would make Section 18.3 go away. Unfortunately, I don't have a magic wand. Sometimes I pretend I do. And so we have to live with it, and it is causing trouble. It's causing confusion in the real estate offices, and it's really causing the smaller condominium corporations a hard time. One of the reasons for that is they don't understand why they are now being asked for other different forms of certificate that they're told they have to provide. And lawyers, real estate lawyers, continue to ask for the form of condo certificate that they have always asked for in the past. So now what I think the thought was is that Form 37 would replace what the lawyers were asking for to close a real estate deal. And it hasn't. And that's causing some pretty bad feelings in the condo corps. They feel that, especially the smaller ones, the ones that can't afford a management company or can't afford a full-time administrator. The feedback we're getting is why do I have to provide this? And our only answer is, unfortunately, you're required to provide it by the law. And you have 7 days to do it. You can charge $50 for it. And it's not a very satisfactory situation right now. And I'm not sure how best and most efficiently to resolve it. I have no discretion. I have very, very little discretion under the Condominium Act. I don't have the type of discretion that I have under the Land Titles Act to determine things. I must not register without this Form 31. So that's an issue. That's an issue for the folks who have to obtain the information and the folks who have to provide the information. Fees and fines. There are some maximum amounts in the regulations, in the condominium general regulation. The maximum amount that a corporation may set out in its bylaws as a fine is $500 for breaking a bylaw and $250 for breaking a rule. There is a provision now about how frequently the fine may be imposed, or like how it might accumulate. So you can't impose the fine more than every 7 days. So you can't say every day it's $500. Which is what condo corps used to do, apparently. There's also maximum amounts that the condo corp can charge for providing documents. 25 cents per printed page. Who here thinks that 25% covers the cost of printing a document? and $5 for each electronic document. All the condo corps that we've talked to, and you may or may not know that we now have 305 registered condominium corporations. $5 for each electronic document. We are encouraging folks to upload their important documents to the Land Titles office, their corporate records folder, so that people can find them easily, and that they could obtain those documents directly from a download from the Land Titles electronic registry. So we'll see how that gets taken up. Maybe that will relieve some of the information seeking burden for condo corps. Land Titles filing requirements are pretty fundamental. I explained to you previously that bylaws are no longer registered at the Land Titles office. They are filed. So the 3 notices that have to be filed at the Land Titles office from time to time is a notice of directors within 30 days after each annual general meeting, a notice of change of address if the address for service of the condominium corporation has changed, and a notice of change of bylaws. So the notice of change of bylaws would also have the bylaw attached to it. And so that would be uploaded into the corporate records folder. We were a little bit chagrined to realize when we started doing our public education campaign, we have the address of all the condominium corporations in the electronic registry, and we downloaded them into an Excel spreadsheet, and we did a mail merge, and we were pretty proud of ourselves that we mastered that. And we sent a letter out to each of the, at that point in time, there were 295 condominium corporations. We had 3 different mail outs. We had one for condos over 10 years, one for condos under 10 years, and one for 2-unit condos. Approximately half of condominium corporations are 2-unit condos. I think there's 163 of them out of 305. Only to have probably half of them come back in the mail. Some came back from duplex condo owners who did not realize they were a condominium. That was an eye-opener for those folks. And a lot of them came back because they went to the developer's address, because the developer or the developer's law firm address was used when the condominium was created, and no one understood that they should change that address at any time. So that was quite a learning experience for us at Land Titles. Whenever a condominium, anyone comes in from a condo court to ask about a Form 31 or to file a notice of directors, we also ask them to check their address for service and get them to file a notice of change of address at that time. But that's really all that we can do. Yeah. So there's other things the condo court may file if it chooses to. These are the things that the Act or regulation says specifically it may file a notice of change of directors between annual meetings. Doesn't have to, but it may. And it may file a reserve fund study if it wishes to. It doesn't have to, but it may. As far as I'm concerned, whatever a condo corp wishes to file, they can approach me and ask me whether I think it's something that they can file, and we'll file it for them. Because again, especially for the smaller condominium corporations, they don't have the resources or website to make these documents available to people who are asking for them. There's no reason why they can't point folks to the Land Titles electronic portal and have them available through there. So we'll see how it goes. I mean, it's been a year now. I wish I thought of doing this before coming today, but I didn't. I'm sorry, I wish I could tell you how many condo corps we've dealt with in terms of getting their filings. Just don't know. So that's all that has to be filed after the condominium is created, because of course at the time of creation, the condo corp has to file declaration, a plan, a notice of directors, a notice of address, a schedule of voting rights, a schedule of unit entitlements, depending on the type of condominium, Might also have to file a phased development disclosure statement, a converted building assessment report. You know, I'm talking about after it's been created. These are the filings that need to be made. More information. There's lots of information on yukoncondos.ca. There's links to the act and regulations there. There's fact sheets on specific topics. I think there are 14 fact sheets now. I think this list might be missing one. No, I know what it is. There are 14 fact sheets, but there's also a really terrific timeline graphic. It's a it's what communications people call an infographic. It shows the timeline from for the transition periods for pre-existing condominiums, for new condominiums, for over 10s and under 10s, about insurance and the reserve fund. And that's what's referred to here as the key timelines. So if you go to yukoncondos.ca and go to the resources link, you'll see key timelines there. And that's been really, everyone that we've given that to has found it very helpful. I find it very helpful. It's at a glance. It helps me. And if it's under 10, and then you can fit it into, especially for insurance. Insurance is the one that's slightly harder because it's coming up sooner. That is everything.